Yes, we are.
Mr. Rogers, are you likewise ready to proceed?
Yes, Your Honor.
Now, this morning, or rather, at some point last week, I was emailed a number of additional motions.
I don't think that's the jury on yet.
I have 2 from the state, and I believe 3 additional motions from the defense. And I assume, or I've been told that it was the intention of both parties to file each of these motions, all 5 of these motions under seal. Mr. Hermes, was it your intention to file your 2 motions under seal?
Your Honor, I think I just emailed my motions. I will file them under seal. Or at this point here,
until we know the condition of the jury, once it is actually filed with the clerks, it will be under seal.
What do you mean by until we know the condition of the jury?
I don't know if Your Honor understands the question or not. But at this time, it's my recollection, unless I'm wrong, that I emailed a copy of my motion in limine, the one concerning lighting, to you and to the defense.
Yeah, I didn't want to put assertions on you about the sealing. I know that Mr. Muller's 3 motions, there was a request, or at least you informed the court that your intention was to file a request that they be filed under seal.
Yes, Your Honor, and I prepared an order granting the request to file under seal.
And so, Mr. Hermes, your request concerning the lighting, are you requesting that it be filed under seal?
Yes, ma'am, I did.
Okay. And then you had an additional one concerning lighting. And the second one went to an attempt at reconstructing a video and or photography. Is that one likewise? Oh, I'm sorry. One Mr. Fine filed went to the testimony concerning sleep deprivation.
And Your Honor, that one was filed under seal Friday afternoon.
Well, none of the sealing happens until I issue such an order, so I'm assuming that's your request. And if you filed it, I don't know whether or not the clerk put it on or not. Nevertheless, did you provide copies to the defense?
We did, Your Honor.
And do you have any objections to the state's 5th motion in limine, as well as their motion in limine concerning sleep deprivation and any sleep-related condition?
We do, Your Honor.
You have objections?
Yeah, we object on, yes, Your Honor.
To each of them?
Yes, Your Honor.
Oh. Well, let's begin with the state's 5th motion in limine. Mr. Hermes, are you ready to proceed?
Which is that going to be the one concerning lighting conditions, Your Honor?
Yes, sir.
Okay. Your Honor, do you want this in the form of a proffer, or would you prefer this in the form of testimony?
I would prefer a proffer, but depending on the nature of the defense's objections, we may have to have testimony.
All right.
If I just clarify, this is you don't want me to get into the video with regard to the lighting that the Rangers did, correct?
That's correct.
Okay, I'll wait. I'll wait to have a hearing on that, Judge. So I'll agree to that.
And I presume we're not going to have any expert testimony concerning sleep deprivation or any sleep-related condition without a hearing. Or that's Mr. Fine's motion.
Yeah, my concern with that, Your Honor, and I only spoke briefly with the defense, but my concern was any mention of it in an opening statement. So obviously we don't, not knowing what their case is going to be, we wouldn't anticipate them getting into sleep deprivation until their case in chief, but we didn't want any mention of it in an opening statement, but specifically related to, as the motion states, anything concerning negating mens rea or men's culpability. Judge, just briefly, I'll let Mr. Mullen supplement. Our defense is self-defense, and so we want to present all the facts and circumstances that apply to our client. So the fact whether she was sleep deprived or not is just a fact that the jury may consider, and for whatever weight it's worth, and applying that to the facts and circumstances
Your Honor, if I may, the issue goes to Texas Penal Code 8.02. Mr. Fine's motion discusses diminished capacity. Diminished capacity, I've litigated the issue in death penalty cases. That goes to a mental illness. We're not alleging that our client's mentally ill, so this is not a diminished capacity defense or issue. So we wouldn't be bringing that up anyway. So.
Well, just from the body of the motion, I presume that, like most of you all's motions and rules, this is just another reminder for everyone to follow the rules of evidence and not to enter into areas that might require expert testimony. I think sleep or lack of sleep certainly may be relevant, and whether or not it rises to the level of sleep deprivation or any sleep-related condition, that might be an area for an expert. I don't know. But I don't think statements regarding a person having had a limited amount of sleep should necessarily be off limits unless it goes much further than that.
And Your Honor, we agree with that. Again, you know,
Okay.
Yeah.
So, Judge, just the factual issue and not get into further expert-related testimony until that time.
So just so we're clear, as it relates to the state's fifth motion, is that both parties agree that there will not be any reference or alluding to in any manner, directly or indirectly, the existence or non-existence of any attempted lighting, reconstruction, video, or photography attempted by the Texas Rangers.
State agrees to that.
Yes, Your Honor.
And insofar as it relates to the state's motion in limine, specifically regarding sleep deprivation or any sleep-related condition, the parties are not precluded from mentioning a lack of sleep, but anything that might need or require expert testimony in this area, you're precluded from entering into that area without the hearing.
Yes, Your Honor.
Okay. Deputy Warren. So and now, let's turn to the defense's newly filed motions in limine. And let's begin first with the defendant's motion in limine regarding George Reese. I hope that's the correct pronunciation for his name. And any evidence concerning lighting. Has the state had an opportunity to review this motion?
Yes, Judge, I've had an opportunity to review the motion. It's my understanding that it's very similar to the state's fifth motion in limine. And I think to the extent that it puts off limits anything that would be based on expert testimony subject to a hearing, we would have no objection. As far as any testimony regarding what we think the evidence would show as the lighting conditions were, whether they're going to say it was dark or we're going to say it was light, that wouldn't be based on expert testimony, the state would ask that not be off limits, of course.
But Roger, you jumped up. I'm assuming you have something to say.
Just on the understanding, I mean, there's a factual dispute probably about the condition of the lighting in the apartment. So I think both sides can go into what they believe the lighting was without getting into down the road on expert testimony.
I think that's fair.
And Judge, that would just require the court to limit the motion in limine, because the final request is that the court preclude the parties from discussing any possible testimony or opinions from any other source regarding lighting.
Well, I think we can have reasonable discussion concerning someone's description that it was dark. Now, if you want to have an expert to tell us how dark or how much light a television being on gives off, or how much light a computer gives off, if we're going to venture into those areas or into the specificity of what is dark and what is light, then of course the motion in limine will be granted insofar as the specificity of what is light or dark, to the extent that you want to rely on expert testimony, if that makes sense.
Yes, Judge.
Judge, can I ask for just a look? May I ask something, just seeking absolute clarification just from my end?
Yes,
Because
sir.
I do want to cover this briefly in an opening statement. So the testimony of lay witnesses or the observations of lay witnesses, having done no expert analysis, but their observations of the light in the room, given certain conditions, that is fair game.
Yes.
That's what I thought Your Honor ruled, but I wanted to make sure that was crystal clear.
Do you have any objections to that, Mr. Muller or Mr. Rogers?
I guess I'm just unclear because the only people that were there at the time was my client and Mr. Jean. So I don't know how. I mean, I guess, well,
I don't know how
okay.
there's so much I don't know. But I don't know. We'll see how the facts shake out. And second motion in limine filed by the defense related to the state's use of the term victim or victims. I'm certain that, generally speaking, the state is well aware to use the phrase complainant or complaining witness. I don't know that every person, lay person that might take the stand may not use the phrase victim. Someone might. I'm just astounded that all of these motions in limine that we have filed are just reminders to everyone to follow the law. So insofar as the state is concerned, please, as best as possible, limit your references to Mr. John as the complainant or the complaining witness. Okay. So in essence, I guess that is granted. And last, but certainly not least, is the defense motion in regard to the state's use of data extracted from the defendant's cell phone or received from the defendant's cell phone. Is there a proffer on the part of the state?
Yes, Judge. I know the court previously said that you would prefer to do a proffer as opposed to live testimony. Proffer is going to have to be sort of divided up because the motion in limine is sort of divided up into several different objections. By my count, I see a relevance objection, which kind of reads as an authentication objection, a 403 objection, a confrontation clause objection, a 3836 objection, and a due process clause objection. Michael, am I reading that right?
Except the part about the relevant objection is not an authentication question. We're not disputing that, like for instance, Mr. Slows, who is an expert, extracted certain data from Ms. Guyger's phone. We're arguing that certain things that the state wants to get into with regards to that data is not relevant to the case in chief. So it is a standard 401 objection that I'm making as to those documents that are from the cell phone, Your Honor.
Okay. One moment, Judge. Judge, may I approach?
Yes, please.
What I've provided to the court are the cases of Butler v. State, 459 Southwest 3rd, 595, Tienda v. State, that's Tienda, 358 Southwest 3rd, 633. Rand v. State, that's an unreported 14th Court of Appeals opinion. The Westlaw citation is going to be 2017 Westlaw 4273177. Price v. State, an unpublished Dallas case, Westlaw citation 2019 1186664. Jackson v. State, another Dallas case, Westlaw citation 2015 3797806. Walter v. State, which is a not yet published Eastland opinion, Westlaw citation 2019 Westlaw 4135461. Snow v. State, an unpublished Fort Worth opinion, 2019 237734. Stevenson v. State, unpublished Amarillo opinion, 2011 4027721. And U.S. v. Tolliver, the 7th Circuit federal opinion, citation 454 F. 3rd 660. Starting with the relevance of the evidence, Judge, it's my understanding that the evidence that's objected to in this motion in limine is the content of text messages between the defendant and her partner, which shows several factual issues. One of the issues is that the text suggests that the defendant and her partner were engaged in a sexual relationship, and that they were discussing that relationship on the night of this shooting. The text messages also indicate that the defendant was texting that partner while she was on the phone with 911.
Okay, hold a second. Wait a minute, hold on. Why do you have a laptop in here?
I'm so sorry, I'm the investigator.
No, I asked you, why do you have a laptop in here? Are you an attorney?
No, ma'am.
Please give that laptop to the bailiff, and you put it wherever you wish to put it. I've asked, I don't know how plainer I can make it.
So sorry.
And why are the,
I don't know what's happening. It just,
I know, please bring it to me, sir. Just please bring it to me.
so sorry.
You've been here more than anybody. You've been here almost every time we've had court. I don't even know how this could happen.
I
I don't need any apologies. Just let me have it. Just let me have it. And why are the people locked out? This is the people's courtroom. Let the people come inside.